Good morning, ladies and gentlemen. Good morning. We are covering the YSL trial, and today there is going to be an important ruling in the case involving Young Thug and other defendants. Today and right now, the judge has to consider whether or not Deputy District Attorney Adrian Love injected herself in the case, and now they want her removed because she is now a witness. So the judge has to rule on this. And I don't know, I said this early on. I don't know if this is going to go in the defense's favor because listening to the hearing, which you guys are probably not haven't heard yet, it appears the judge is trying to throw uh, an alley-oop to the prosecutors. And what stood out for me is the judge said, "Well, y'all didn't object to it when she did it." Actually, they did. They did object to it, but now the judge is saying that if you want to preserve this on appeal, now the judge is looking for cover for himself as well. Because if you don't make an objection during the testimony, then it won't be heard on appeal. So why is the judge saying this? We have to analyze why the judge is giving an out for the prosecutor when in fact the prosecutor injected herself in the conversation. She said she made it appear that those two had a conversation by themselves. So my question is, will there be a pushback from the judge as well as the prosecutor to allow her to continue on this case? I knew, as well as attorney Akeisha El Shabazz, who was a guest on my show, spoke about this when it happened. He said, "Wait a minute." Attorney Shabazz said, "Wait a minute." She's now became a witness because she said that she had a conversation, and we don't know if that conversation was witnessed by the other investigators. But this appears to be a problem. This appears to be a problem because now you two are having conversations. You calling her. You're calling her and just checking on and everything, which is kind of, I get it. You want to keep the witness in the loop, but do you do this to all your clients? And not clients, but witnesses. Then you bring it into, think about this for a second, ladies and gentlemen. With all these pleasantries that she was giving the witness, AB, we're going to say AB, but they've said her last name. But the media is under a rule not to say her name. However, the only person I heard, and that's today, that used the initials was the other prosecutor who came in to argue the motion for the state on not disqualifying DA Adrian Love. But everyone's been saying her name. That's how everyone knows the name. It's been played out. The lawyers have been saying it. They haven't even cautioned themselves not to say her name. They've been using initials. So I'm going to call her AB from this point on, unless others start to continue to call her AB. With that said, this judge, in my opinion, is not going to disqualify her. And I think it's kind of weak for him to say that, well, didn't you guys, why you guys didn't object? But Judge, you are the referee in the case. If you see something that's foul taking place, you gotta err on the side of caution for the defense. I mean, this is kind of like, I'm not saying the judge is being the second counsel on the table, but if it's wrong, and you don't necessarily, the lawyers don't necessarily have to object. If you know this is wrong and you know this can be an issue, and they're going to raise the issue in an appeal, she doesn't get disqualified. The judge is the referee. A referee got to call the strikes when it's a strike. He has to do that. You just can't sit around and just let them have free reign on running your courtroom. And this is my opinion. This is not the judge's opinion. This is my opinion. If you knew that, if other lawyers around the country watch the same testimony as everyone else, and they said, "Wait a minute, she's testifying. So wait a minute, you got it. No, now we got to change the tables. We got to switch seats now. Not the table, switch seats. You now have to sit in the box, and now you got to be cross-examined by the defense attorneys because you just injected yourself in this testimony by way of questioning your own witness. So this is a problem. This is a problem, and we need to be able to flush out the issues. And what else happened? Because many people saw that, at least heard, because we can't show it on camera. We heard her testify, and she's not too favorable. She doesn't like this prosecutor either. And I don't know for what reason, if it's some things that were said that we're not privy to. Well, guess what? On April 8th, that witness will be taking the stand, getting back in the box again. But will she get in the box and be questioned by DA Adrian Love, or will it be another prosecutor? We'll see. My guess is, based on the way the judge has been ruling pro-prosecution, I don't see this judge going to take off the case. And listening to how he just morning, how he's asking questions to the defense, it's kind of troubling. I would just say that it's kind of troubling, ladies and gentlemen. It's kind of troubling, and to even suggest that, well, the defense didn't object at that moment in time by the judges saying this, not the prosecutors, not the prosecutors on today, but the judge is saying that. Well, judge, you actually questioned witnesses that were on the stand that the prosecutor didn't. That was in their question. You turned around and questioned the prosecution witness. So, are you going to be that technical and not give favor to the defense in this case? And you know it's inappropriate. You were a prosecutor as well, so you should know this. It doesn't feel right. It prejudices the defense, and it comes across as bias. It comes across as bias. And I'm just going to say that it's my opinion. I know, Judge, you're probably going to see me today and give me the screw face look and say, Mr. Byron, I heard what you said about him. But Judge, listen, I'm beholden to no one. I'm beholden to no one. I am not a part of the prosecution or the defense team, but I do call out things when I see it looks kind of crazy. I don't care if it's defense or prosecution. So when I come to court, sir, please don't send your sheriffs over there to tap me on the shoulder. Let me see your camera, sir. Let me make sure you're not taking pictures of different people. I'm a professional, sir, and I've been doing this for 30 plus years, and I don't like people playing with me and playing with my job, because that's not me. I'm not telling the sheriffs how to control the courtroom. I'm sorry, guys. I'm venting because I'm telling you things that happen behind the scenes that you're not seeing. I'm telling you these things are going on in the courtroom, but they don't want you to know. But I'm going to tell you. They haven't taken the bench yet. We still are watching the seal in the courtroom. I'm gonna bring the seal up so you know that you're not missing anything. But at this point, I want to make sure that I'm calling this. I'm the referee on outside of the court, outside of the trial. And if I see something that doesn't look kosher, I'm going to call it out, because this is history. I'm going to say something else, ladies and gentlemen. Many people haven't reported yet. This trial has now, the time this trial has been engaged has exceeded the O.J. Simpson trial, with jury selection and the trial going on. I don't care what the judge says, because in Judge Ito was the presiding judge in the O.J. Simpson case. And when that jury selection process started, that's when they started rocking and rolling. This one has exceeded that. So they are already breaking records. And we already learned just yesterday that the prosecution has already suggested that they have 150 witnesses over 4 months. And that's without the cross-examination, notwithstanding the defense has to put on their case in chief. And then their case in chief will be cross-examined by the prosecution. We're looking at over a year plus. Over a year plus. 150 more witnesses is insane. It's insane. And this has exceeded the O.J. Simpson trial. And there was one other trial that went 7 years in history, in American history. Let's don't let this be this one comes as close to that. It is two. You got 6 defendants. You have at least one is accused of bang bang. And that's Shannon Stillwell. Okay, I just got a alert just now. Stand by, guys. I just got an alert. That's why I froze. I apologize, guys. I apologize. Hold on. Stand by. Sorry, guys. This is something came in from another part of another courtroom. Okay, guys. Okay, so stand by, ladies and gentlemen. We are going to we're going to listen to this. We're going to watch how this judge makes this ruling, and let's see if he let's just say help the prosecution or the defense. Let's just say that. Let's just say that. Okay, listen. Someone said something, and I too want to know what was it. Here we go. We're back in the court, ladies and gentlemen. Here we go. Let me shut up and turn. Judge, you're eating in the court. Judge, you're eating in the courtroom, sir. You're eating in the courtroom, sir. And we got to get the sound right in the courtroom. Hold on, guys. Hold on. We don't know what's going on. Come on, Judge. Okay. Get that man some water.
Can we ask somebody to come back in, please?
I too want to know what's in that, what's in the sealed document that the defense hasn't even seen yet. Interesting. Interesting. Sealing documents and the defense hasn't seen it yet. Very interesting. She might be an informant, and that may be, we don't know, because that would be something they would seal. She's an informant. Who knows? I'm just saying. I don't know. Only speculation, ladies and gentlemen. There's only a few reasons why a judge would seal a document, and that's to avoid exposing her or someone else in a criminal proceeding. Okay, guys, we're going full frame. We are going full frame, so I'll be in the background.
Everybody's perfect. All right, thank you, Sergeant. All right, Mr. Uhalski, what were you able to parse out as it pertains to the state's exhibits?
All right, I was able to get some clarity on the two issues we left off on, starting with, I can emphatically state in my place that Ms. Love was never alone with Ms. Bennett for any oral conversations. With respect
to the bench conversation.
Yes.
Outside courtroom bench conversation.
Yes, and that one, and I'll clarify that. It started out with Ms. Love and Antonio Long, and then there was this representation from AB about harming herself due to the fact that, the state wants her to testify, by the way. But after that point, Adrian was sort of backed off, and then Tamika Kelly and Partrina Baker then went ahead and got with Miss AB at that time. And I will say, if Your Honor thinks that cross-examining AB on that conversation is not enough,
Bennett.
Yes, sir.
Okay, all right.
If Your Honor thinks that the defense cross-examining AB on that conversation and the circumstances surrounding it and everything about it is somehow not enough under the Constitution, then you have those additional witnesses. The next part is the text message conversations, okay? I wouldn't even call them conversations, but they're contained.
Okay, let's the first, Grant, tell me which text message conversations, because I want to say there's 32, 33, and 34 alpha alpha. Is that correct?
Yeah, 35 alpha alpha.
Oh, and 35. Is it started at 33 or 32? Yeah, you all have them, so I don't. So,
well, the ones that pertain to Ms. Love's conversations, the text communications, are 35 alpha alpha.
Okay, so let's take a look at those.
And so when you do take a look at those, and I'm looking at them now, they I'll just characterize them. They're sort of pleasantries. How are you doing? Good morning, etc. I mean, we can take a look at every word of them. And like I said, they speak for themselves.
Let
And
me
again,
take a look at 35
yes, sir.
alfalfa.
And their approach.
Yes, you may. Thank you.
I'll give Your Honor some time to look at those, but I'll be ready to continue at the court's pleasure.
Okay. All right.
So what I would say about those text messages, Your Honor, as you look at them, they're pleasantries, they're administrative, they're collateral. And the larger point, one of the larger points is that these are just text messages that Ms. Love sent to AB as part of, we want you to testify, we're, using you in the case. For the most part, AB doesn't really say anything except for those two instances, and those are administrative responses in the first place. And even more than that, the idea that a prosecutor texting a witness about coming in to testify and how are you doing and all this other stuff, that's just text messages that occurred between Ms. Love and AB. That's not unsworn testimony. And when it comes to the ability of the defense and the right of the defense to impeach on matters like that, Your Honor, I want to point you emphatically to Scott v. State. Okay, that's a 2020 Georgia Supreme Court decision, 309 Georgia 764, and again that's 309 Georgia 764 at 770, and it says as follows: under OCGA 24-6-621, a witness may be impeached by disproving the facts testified to by the witness. But this statutory provision does not provide a party with an unlimited ability to impeach a witness by contradiction. To use an example of something that did come out maybe in testimony, isn't it true you were late to the meeting? Okay, yes, no, it doesn't matter what the answer is, it's collateral. Scott says a party may not use extrinsic evidence to impeach a witness by contradiction on a matter collateral to the material issues at trial. Whether AB was late to the meeting, not material to the trial. It goes on to say that even under the former rule that preceded 621, a witness may not be impeached based upon a discrepancy relating to a wholly immaterial matter. And even further in Scott, going on to 771, it talks about how the person's the ability to disprove something that's relevant to credibility, that a discrepancy on that point does not relate to a material issue in the case. So I'm going to leave the court with Scott. I'm going to leave the court with my understanding of the extent of the text communications that would have just been between AB and Ms. Love. But I want to leave the court with the final impression, again, reiterating that those text messages are not testimony. And really, if the defense wants to talk about them, they could ask Ms. Bennett. And so we would ask the court to deny this motion.
All right. One more thing. Do you all have a copy of the affidavit for the material witness warrant? I'd have to do an order unsealing it.
We can certainly.
Do you have a copy of it with you, or do you have? Can you get me a copy we'll
provide a copy to the court immediately.
Can you all get me one in the next 5 minutes?
Yes. We're
Okay.
We're working on it now.
All right. Okay. All right. So I want to take a look at it,
Yes, sir.
and I may, depending upon what it says, make some other additional findings. Okay.
All right. Thank you, Your Honor.
So I'm just going to recess in place.
Okay, so what just happened? that affidavit that was filed by the district attorney, which is sealed, the judge is now unsealing it. Now, is that going to be a temporarily unseal, or is that going to be a permanent unseal? Because I think at this point, if he unseals it, I need to snatch it. If he unseals it, I need to snatch it and see what's in the document. So let's see if I can grab it within the next 10 minutes. Let's see if I can grab it within the next 10 minutes. Let me see if I can grab it within the next 10 minutes. Stand by, ladies and gentlemen. I got to go to work. Stand by.
For a sec, please. It's too loud.
All rise. I didn't take roll call today. Let me take a quick roll call. Vanderveer, I see you. Galatians, I see you. Michelle, I see you. Who else is in? Okay, check in, everybody. Checking in. Let's see. Latasha, I see you. Latoya Lucas. I know we got shot the members first. D, I see you, D. Okay, who else we got? We got to shout the members out first. The members. Miss HLS, what's up? I see you there. I see you. Shout out to all the members, the law members in the building. The law members in the building. Okay, I may mention a few other ones, maybe. Karina. I never seen before, Karina, but then I get so many people up in the building. Good morning. Good morning. Good morning. Good morning. Good morning. Good morning. We got listen, we got something going on today. Just members, just keep your notifications on. We got something going on just for the members. Keep your notification on. And now I have memberships section in both my backup page, Dennis Byron and Hip Hop Inquirer. But some of you have subscribed to Hip Hop Inquirer, but when we go on members on Mr. Dennis Byron, where we have a lot of members that haven't really pushed their membership on the Hip Hop Inquirer, so we're going memberships on a story on Mr. Dennis Byron's page, on my page, personal page. For those who know, just got to go ahead and the members know. Those who know who know, because sometimes I have both streams going on simultaneously, so it may get confusing for some, but it's going down on Dennis Byron's page. And I'll drop that link today. Sandra Love, are you related to the great Adrian Love, the prosecutor? Are you related, Sandra? Or is that you, Sandra? Is that you, Ms. Love, Ms. Adrian? That's your middle name? I don't know. I'm just speculating. Come on, Judge. Come on, Judge. Release the document, Judge. Release. It's not released yet. I'm trying to grab it, ladies and gentlemen. I am trying to grab it. It's not released yet. I know you come in with that last name Love. You're getting the business today. You are getting the business today.
Why don't you come to the podium?
Yeah.
Thank you.
I believe this is what the court's going to do, but we just wanted to make sure that we redact and make sure that it doesn't come out to the public, any of this biographical information, date of birth, address, stuff like that, if that makes sense.
I think that could be arranged.
Sure.
Mr. Steele, what I'm going to do is I'll redact out the biographical data of the witness.
No opposition.
Okay.
Okay,
All right.
thank you.
All right, so we'll just do that before when I unseal it, okay?
Thank you, Your Honor.
Okay, all right.
So there you have it, ladies and gentlemen. That's why I can't grab it, because they got to redact biographical
34
information.
And 30.
Hold on.
Yeah.
Because I'm on it right now. I said, where's this document at? Where is it at? Do your redaction, sir, because I need to see this as well. The red lipstick hustler Lily. She's a hustler. that is why I couldn't grab the document, because the redactions haven't been done. So this is good. This is good. Why didn't the judge just redact the information before he sealed the whole document in the first place? This is okay. I understand. Be more shorty. A member in the building. Be more shorty. Okay, make a redaction, sir. That won't take too long. We can redact that. We got that digital whiteout. Eat, pray, and love. Yes. Yes. Eat, pray, and love. I can't. Why can't it be love, pray, love, and eat? Or love, eat, and pray? Anyway, you picked. It's your name. It's your name. Come on, Judge. I'm trying to get that doc redacted. Let's see what really happened. What did they say in the affidavit? What did they say in the affidavit to get that warrant? What did they say in the affidavit, ladies and gentlemen, for them to be able to get that material witness warrant? Come on, Judge. We see you chewing in the courtroom. Judge, we caught you, Judge. Slick. Put one of those now and laters. Who remember the now and laters? I don't know. I don't know what you eat, Judge. We're gonna find out later on during the post interview after the trial. What were you eating in the courtroom, sir? Judge, we see everything, Judge. We see everything, Judge. Okay. B-more, come on. You gotta listen. You gonna have to, B-more, you getting the timeout, B-more. You're a mess. You are a mess. Everybody sneaking food in their mouth. Listen, I know if I did it, they will be all calling me out. Judge screamed on someone. You remember the time the judge screamed on the girl in the back of the courtroom? Stop chewing gum. You remember that, right? Okay. Yeah. Okay. No, I understand that. I understand. What if he's diabetic? I get it. Okay. Okay. See, there you go. Now you're gonna put me on a guilt trip. So can we all eat? Can we all eat in the courtroom? Can we just have a free for all? Can I just bring my lunch in? Can we just eat in place? Mm-mm-mm. Well, you'll give me hell. Oh my goodness. Hold on. God, oops. I forgot to do some administrative stuff like send a daggone tweet. Oh my God. Let's see here. Hold on a second here. While the judge is munching, let me send this tweet out real quick. Oh. Let's see here. Jones says, see you in the building. Okay, guys, waiting for this judge to because he's crafting a ruling. Let's just see what this ruling looks like. Anyone want to take a bet right now? Anyone want to take a bet that this judge is not going to disqualify DA Love? Anyone want to take a bet? Come on, let's take a bet. I say he's not going to do it. I don't see his posturing doesn't say that. I'm prepared. I'm prepared. And for those who care, in the thumbnail that you see, that those pictures within the thumbnail, I shot those pictures in the courtroom. They're not screen grabs; they're actually shots that shot in the courtroom. Shameless plug. Well, she would have had to submit it yesterday. It was a response, and that response was due at 5 p.m. yesterday because there's no court tomorrow, and he's ruling today. And that answer was for Vanderveer. I mean, you got be sure that you missed out. I got a freezer full of Haagen-Dazs. You missed out. Buy one get one free. You paid a whole $6.99 for a large size, and I paid $5.99 for 2 pints. You should have went when I told you to. But maybe you didn't go to the public. You may have went to another store. Okay, those documents. Okay. Hold on a second. Just got a breaking news. Okay. Oh, okay. You up north. Okay. Wait. Hold on. Can you guys hear the beep in the background? Let me know if you hear a beep in the background. I don't know if that's coming across as well. I'm going to tweet you my freezer with all the Haagen-Dazs in there. Okay, you guys. Okay, you'll hear it. Okay, so we're going to fix that. I'm so sorry about that. Well, no one told me. You'll be hearing things. You don't be telling me anything. You'll just be sitting there listening. I wonder if he knows there's a beep in the background. No, I don't know. You should tell me. You'll hear it. Don't let me be out
In a
like
position to give you my thoughts on ruling on this particular issue. The court has considered the issues framed in the defendant Williams' motion to enforce the disqualification of Prosecutor Love. And to that end, I've considered what has been pled in Mr. Williams' motion. I've also considered the state's response to defendant Jeffrey Williams' April 1st, 2024 motion to disqualify. I've also considered the arguments of counsel. I've also taken into account and will take judicial notice of the proceedings to include the transcript of proceedings on, and in particular, 28 and 29 March of 2024. And the court also has had the opportunity to review and consider the following exhibits. States 32 alpha alpha, states 33 alpha alpha, states 34 alpha alpha, and states 35 alpha alpha. In considering these motions, the court has also considered the defense's 3 groupings of the examination of Miss Bennett as it pertains to their assertion that Miss Love has inserted herself and become an unofficial witness. In regards to this, I have also considered and will consider for purposes of the motion the statements that were made in court on the 28th and 29th of March, even though video was shown to the court. In regards to those, the official transcript will be the record that the court considers. I've also considered the communications between Miss Bennett, the witness, and purported to be Miss Love and other members of the staff of the district attorney's office. And then third group of consideration is the communication by telephone at various times between Miss Love and Miss Bennett in states 35 alpha alpha. In considering those, the court has also taken a look at the cases that both the state as well as the defense has proffered and invited the court's attention in respect to this issue of Ms. Love and being an unofficial witness. The court is of note considered Bonner as well as, and Bonner's at 192 Georgia Appeals 721. And also the court has also considered Cantwell versus Kent, 254 Georgia at 556, and Scott versus the state 301 Georgia.
Yeah, write those case numbers down.
764.
You're gonna pull a case
and 24-6-621, as well as rules for the Georgia Rules of Professional Responsibility.
Dum da dum dum.
Uh, 3.7. To the defense's arguments and assertion in the first grouping that has been brought to the court's attention on March the 28th and March the 29th of 2024, the court has heard some concerns from Mr. Steele saying that those conversations could not be challenged by any other examination than Ms. Love, and has thus asked the court to disqualify her. The court has considered that particular request, and in regards to the colloquy that is had between Ms. Love and Ms. Bennett, as referenced from the transcript, in the interest of fairness and judicial economy and clarity, the court will unseal the affidavit as it pertains to the material witness warrant that the state sought to comply with to help to facilitate Ms. Bennett's complying with being here as a witness. I will make that available immediately. I will do two things. I will sign an order unsealing that particular affidavit. I will also block out the proprietary information as it relates to Ms. Bennett from that. But Mr. Steele and Mr. Uhelski, I will make the balance of the affidavit in its entirety available, and I believe that will also provide you with information as to others that may satisfy your concerns and in respect to that issue.
I knew it. I knew it.
The second area of communications from the courtroom bench outside the courtroom as it pertains to Ms. Love. I believe that Mr. Uhelski is proffered and stayed in his place, that Chief Investigator Long would be the person, as well as the two victim advocates that can provide information in respect to any communications that may need to be tested or heard of during that particular period as it relates to that issue. And then thirdly, the communications by telephone at various times in states 35 Alpha as it relates to Ms. Love and the witness, Ms. Bennett. The court in reviewing those doesn't find anything that would be
Told you.
other than the one advocate's attempts to seek scheduling and pleasantries with the witness. And for those reasons, and applying Bonner and the other cases that the court has cited for purposes of this analysis, I'm going to deny the defense's motion to disqualify Ms. Love.
Told you.
I will also, though, as a caveat to all counsel, just invite you all to just be mindful witness interviews and the importance of third parties being present, for the reasons that our professional code of
There he
responsibility
being
tells us.
condescending
So
to
we
the
don't
defense.
inadvertently make ourselves as lawyer as witness. So with that, that's the court's ruling. Mr. Uhelski, if you will prepare a suitable order for the court's consideration, send that to Mr. Steele. And if I could get that by next Friday, that would be the 12th of April. That would be fabulous. Okay? All right.
Told you.
Your Honor,
Yes, Mr. Sharp.
as Mr. Steele, I believe, was the only signatory of the motion and did the arguing. I just want to ensure for the record that the Harvey rule is still in effect. And
It applies to all. So,
thank you.
yes. Okay. All right. One other thing, Wes.
Run me my money. Run me my money for those who have voted against me. I told you this judge would not disqualify her.
Will not disqualify her. No way. Will not disqualify her. I saw it coming a mile away. It's not happening. This case is ripe for an appeal. This case is ripe for an appeal on so many levels, ladies and gentlemen. This case is ripe for an appeal. I'm not saying the judge is biased. You guys are saying the judge is biased. I'm just looking at what is the optics, the rulings, the behavior, and the chastisement of the defense. And even in this ruling and his conclusion, here we go with the you all. You all. What do you mean you all? They didn't violate the rule in this respect. They are filing the motion because they felt that she violated the rule and made herself a witness. But this you all, sir, it's so condescending. It's disrespectful. What is this you all? Say specifically to the prosecution, you should not be interviewing witnesses and making yourself right for a witness yourself. This is incredible. No way, no how that all these rulings are going, well, 90% of rulings are going for the prosecution. Ladies and gentlemen, the lawyers for the defense are seasoned attorneys, most of them, but the main ones are seasoned attorneys. It's incredible that this is playing out on national TV, and it's almost like, well, they're not really doing their job. No, that's the optics. That's the impression, the messaging, the signaling. You all. No, not you all. Address the person or persons that have brought this problem to the forefront. It wasn't Steele. It wasn't Short. It wasn't Keith Adams. It wasn't Weinstein. It wasn't D. Williams. It wasn't the Harvey. It wasn't Miss Westmoreland. Miss Westmoreland. It was the prosecution. So when you say you all, when this issue was raised because of something that is perceived the prosecution did, you are signaling that you are chastising the defense and not necessarily the prosecution. Because if you're talking to me, put a name on it. If you're talking to me and you want to address me, put a name on it. And then if you want to address the other side, put a name on it. Put the other name on it. But don't say you all. Am I wrong for feeling that way? Am I wrong for feeling like this broad brush approach to the rulings is just disheartening? It's disappointing? It's disrespectful? And it's distracting. Tell me if I'm wrong, ladies and gentlemen, and I'll be quiet. I'll go in timeout. I'll go in the corner, put my leg up. You know, my instructors back in the day said, well, if you don't do this technique right, you're gonna have to do this. I don't have a problem with that. But put a name on it. Who are you talking about? You all. Who's you all? I'm not with them. I'm not with them. Distribute your tongue lashing accordingly, sir. It just makes me feel like you all. What are you talking about? You all talk about. Now call them out, whoever it is. When you snap on a defense, like you did, yeah, I saw what you did to Max Sharp yesterday. Max, what are you smiling for? Oh, you got to call a man out like that. He can't smile. This is a human. He cannot smile. He can't have it. He could be listening to something else and he can't smile. What is this? We are grown people here. Like, come on. You can't be talking to people like they're kids. They're grown people here. Judge, you don't see this, but this is coming across as very Napoleon Bonaparte. I am the king. And what I say goes. I am the king. I'm the ruler. Sir, these men put on their pants just like you. And that's what it is. I like Miss Love, but I see what you're doing. I like Miss Hilton, but I see what you're doing. I even called Brian Still out because I had an issue with the Adrian Bean interview that was done in 2023. We can see that he said a lot more with Detective Quinn, and he's not being very forthright when he was talking to Brian Still. But put names on, put the name out there. Don't you all this, you all that. I'm done with you all. I want to protest the word you all. You all is not me. Who are you talking about? I saw the shade yesterday. I saw it. Max, what are you smiling about? Oh, so you want to call him out like, oh, you really calling that man out like that? You just pimp slapped him. What are you doing? What are you smiling about? You think it's funny? I saw when he listen, I saw when he did it to another attorney as well. Who was the other attorney he did that to? He did it to another attorney on the defense. Right, you can't control someone's laughter. Like, what is this? This is crazy.
Okay. All right. All right. I don't think I have anything else I need to add or with you all other than
So what he did was, I'm gonna tell you what he did. I bust the move. So he's going to unseal the affidavit, not because the defense asked to unseal it. He wants the defense to feel like they're getting something, but it was never the defense's affidavit. It was the prosecution affidavit, and it was sealed because of her. She had confidential information on it. So the judge is like,
other than we'll be back in session at 8:45 on Monday morning. I'll cover with you all my administrative order and just to make sure it'll be entered and all of you will get a copy of it. Okay. Anything else? Mr. Harvey.
One logistical matter. If we are to be here pursuant to your 8:45 requests, we need a current order to get us in before 8:30 so we can be here, be ready to go per your 8:45 requirements. If your staff can prepare us an order allowing us to get in before 8:30, we would appreciate it.
Mr. Harvey, I will take care of that momentarily, okay? All right? Okay. Anything else? All right. If not, I'll see you all for 8:45 on Monday morning, the 8th, and our jurors will be present, and we'll take up that, because I believe I told them to be here for 9 o'clock. So we'll whenever they all get here, that'll give us some time to cover any other ministerial that we have to cover. All right. I notice you all have, Ms. Love has turned it over to you all from the evidence that she and the state are wishing to proceed with, consistent with my orders. So unless there's anything else, I'll see you all on Monday. Okay. All right. We're in recess.
Wow, ladies and gentlemen. So you all, you got me doing it. You've seen the hearing, you've seen the ruling, and you've seen that I was right. I was right. This judge wasn't ruling against the prosecution. You all knew that. You all knew that. Go through the motions, pun intended, go through the motions to deny the motion. I get it. I get it. Am I being biased? No, I'm not being biased. But let me see. Put a 1 in the chat if you think I'm being biased as it relates to this trial. Am I seeing, are you seeing what I'm seeing? Are you feeling like the prosecution is getting these wins because perhaps they are more likable by the judge? I'm just giving my opinion. And Judge Glanville, respectfully, I know you have other cases, but this particular case, sir, is going to go down in history for a number of reasons. It's going to go down. These clips are going to go viral. They're going to be used in classes across America, law classes, pre-law classes, evidentiary classes, discuss amongst the intellects. You get it, the intellects, not just the Pammy Pam intellects, but the intellects across America who covers trials and have a respect for the criminal justice system and its procedures. And we're going to be looking at the case laws that were supporting these rulings on both sides. Because at the end, the judge is the referee. He makes the final call. But sometimes we've learned in watching baseball games, the referees have gotten it wrong as well. They have gotten it wrong. They've gotten it wrong. But there's a check and balance in place. And that has to do with making objections and letting it go to the high court. Let it go to the high court. Did the defense mess up the motion? That's going to be discussed. But the judge did give him a bone. We're going to unseal the affidavit that we used to bring in the material witness. And something in an affidavit, I'm going to tell you, ladies and gentlemen, I bust that move as well. There's something in that affidavit that favors the prosecution. But then you ask yourself the question, why was it sealed in the first place? Because if it was sealed to protect the individual, then why is it unsealed now? Why is it unsealed now? It's to support this judge's ruling against the defense. That's the only reason why it was done. That's the only reason why it was done. That's the only reason why it was done, in my opinion. That's it. So will Young Thug be able to get a fair trial? Is the bigger question. Will the other defendants be able to get a fair trial? Is the question. The duration of this trial is going to wear the jury down, or the jurors down. The duration is going to wear the jurors down. And I'm going to tell you, with all these counts and these overt acts that have been outlined and illustrated in the indictment, whenever you have a jury that is out this long, with the exception of the O.J. Simpson trial, depending upon who they like the most and what is like, who is not wasting the court's time or their time, they're going to take it out on somebody. It may be the defendants or it may be the prosecution. But history has shown that it's usually the defendants that will get the brunt of their frustration. That's what I believe. You don't have to believe it. That's what I believe. And anytime you have a trial this long and you remove people from their regular day-to-day activity, this is crazy. I wouldn't want to sit on a jury for a whole year. That's not my life. I never get that back. You don't get that year back. How important do you think this trial is to these jurors? Jurors are going to go through this, and this is going to be over a year. Jurors are going to go through things. They have families. You got one or two younger people on there, but you got to realize that these jurors have their own lives. And telling jurors, even though the judge told them what they cannot do, these jurors are not going to take away a whole year plus of not being on social media. Not that era. It's not happening. They're going to look on social media. They're going to look at news reports. They're going to be watching my video. They're going to be watching your video. They're going to be trying to put all this together and wondering why there's so many delays. They're going to wonder. And then some of them are just going to say, I'm not convicting him for no reason at all. So he might get a mistrial by way of a holdout, or maybe 2 holdouts, or maybe 3 holdouts, because we haven't seen, at least for me, the smoking gun yet. There's still testimony that I view as ambiguous, and I don't think that with the jury instructions that will be given to them, the evidence is going to support a guilty verdict yet. We still got 150 witnesses. And then we got the defense that have to put their case in chief on. So when they put their case in chief on, they may be able to change the trajectory of the way the case is going, or maybe not. And the trajectory could be going in their favor, and they may do too much to get it on the prosecution side. We don't know. This is all timing. This is, it's a lot of time in this case. A lot of resources being spent in this case. Was Thug that notorious in Atlanta? This recording artist that has respect by his peers around the world. We can't forget this guy's collabed with some of the biggest names in music. Is he now being diminished as a common thug? This guy has to pay his legal team. It's weighing down on his budget. He has staff that are probably unemployed now because he can't produce and deliver content to the masses if he's not able to. He's on a bond. At minimum, give this man a bond so he can work to be able to afford his defense properly. This is really draining his resources. And then what kind of artist will he be after being down for 3 years? Because the lifespan of an artist, ladies and gentlemen, the average artist don't have a music lifespan, a career lifespan beyond 5 years. So what if he's found not guilty of everything? He still lost
He still lost. He's found not guilty. He still lost. He's lost a lot. So balance the scale of justice. Give the man a bond. Put an ankle monitor on him. Put conditions on him, but let him create. That's all. Let him create. Because we did hear testimony by Tick, who said he kept trying to tell me this is not the way to go. This is not the way to go. This is not the way to go. We know people change. People change all the time. People change all the time. The person you are 10 years ago may not be the person you are today. You got to get that stuff out your system. It happens. I used to go to the clubs back in the day. I was in the clubs. If those from New York, the Shadow had a day. Thursday night, Leviticus had a day. Friday night, Club 370. Every club, we knew the dates for what club was going to be popping in the city. I was a club animal. I was in there doing my moves. I was doing all. Listen, I was pretty lit back in the day. I'm still lit now, but I was pretty lit back in the day. I'm not like that no more. I'm not hanging in the clubs. I'm not trying to see what's popping in Atlanta and New York and LA. If it ain't a private party, I'm not pulling up. And it's a different conversation. You're not going to see the OG hanging out in the club with a bunch of teen boppers. So, the way Thug was moving back then, I'm not saying he wasn't out there, with his clique, his crew. I'm just saying. I don't know what the shelter is. What are you trying to put me in a shelter for? What, Jay, Miss J, what are you doing? No, I'm never in a shelter. What are you talking about? No. I mean, it's street cred. I don't even think you want to have street cred like that. I don't think you want to have street cred. I'm sure he's wrote some many songs and everything. I get all that, but nothing like your freedom. Anyone who says he'll be all right, put yourself in that situation. Would you want to be in a 2x4 or whatever size the cell is for the rest of your life or for a year? You don't get that time back. You don't. Anyway, with that said, ladies and gentlemen, I do appreciate you. I have another show to do. This is for the members only. Make sure you members that are watching, make sure your notifications on. We're getting into some things. We are getting into some things. Okay, it was for house head music. Hold on. So when you want to talk about house music, where you go for the house music? Studio 54, the Palladium. Come on, we talking New York City. We talking about the clubs of clubs. We ain't talking about these little clubs in the South. We talking about the big clubs in New York. We ain't talking about the Magic City. Magic City. Velvet Room. It ain't nothing. We talking about the clubs where the big ballers came through. The celebrities came through. We talking about Hollywood stars, the Studio 54, the clubs Puffy hanged out in. Come on, you don't want to go. We don't want to go there. We don't want to talk about that. Absolutely, Michelle. Ladies and gentlemen, I appreciate you. I really do. This was a interesting hearing, but I knew the outcome. I didn't think the judge was going to rule against the prosecution. Who thought that? It was nice to see, but it wasn't going down like that. With that said, ladies and gentlemen, I appreciate you. I really do. Until next time for the general public, make sure you locked in. Make sure you are subscribing to this channel and make sure you are supporting it. Support. You see what the support says? Hit the Cash App. We out.